This episode reveals whether your inheritance will survive your divorce. This episode reveals whether your inheritance will survive your divorce.
Welcome to Women Winning Divorce, the podcast helping successful women navigate divorce with dignity so you can protect yourself, your children, and your assets. I'm Heather Quick, founding attorney at Florida Women's Law Group, where women win at life.
This week we had Cary Jacobson on the show, and we had an informative conversation about inheritance, gifts, and what is and what isn't considered marital assets. I hope this episode is valuable to anyone who might be listening. Welcome to this week's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney at Florida Women's Law Group. Today, Cary Jacobson is joining us. Cary is the founder and managing partner of Jacobson Family Law, a virtual law firm serving the Columbia, Maryland area. Cary has nearly a decade of legal experience and specializes in mediation. Today, Cary and I will be discussing protecting your inheritance, understanding what is and what isn't marital property in eyes of the law, and what is considered a gift within a marriage. Welcome to the show, Cary.
Thank you so much for having me, Heather.
Absolutely. And Cary, for our listeners, could you share a little bit about yourself and your practice?
Sure. So I've actually been practicing now over a decade, and I have been primarily handling family law matters during that time. And I started out in the traditional family law world where litigation was part of the practice. But over the years, I really decided that it just wasn't serving my clients and it wasn't serving me. So we transitioned to a completely out-of-court resolution-based practice. We work with clients in dealing with mediation, separation agreements, collaborative divorce, as well as estate planning and prenuptial agreements. And as you mentioned, we are completely virtual, so we really serve all of Maryland and try to get our clients that efficient and stress-free divorce as quickly as possible.
Well, that's wonderful. And how long have you been doing all virtual, if I may ask? Did that stem from COVID?
I wanted to do it before COVID. I've always, really thought that was the ideal, but, people weren't bought into it until they had to do it. And, so many people just didn't think mediation could work if you were in a virtual environment. You had to be sitting across the table from one another. And as we have learned through COVID, that's not necessarily the case. And I think, honestly, mediations go so much better when people aren't necessarily in the same room with one another.
And that's why I asked, because I think that there's a lot of practices that have really moved in that direction. And there's a lot of benefits to both the law firm, but also the clients. There's a lot more options for them, I think, and it saves a lot of time very often. I mean, especially in big cities and congestion, like not having to travel there. It helps a lot. So it was just an interesting thing, kind of off topic, but I was fascinated by it because I think, and especially for our listeners, I think when they hear that, that's why, and it's still, you're still doing it now because it still is beneficial and it works. So that is great to hear. Now, all right, today we are discussing inheritance, gifts, and what is and what isn't marital in form of assets. And I think that's really important. Everybody's always got those questions when they're thinking about a divorce. So let's first start with, how does Maryland treat marital versus non-marital property or assets?
Yes. So Maryland basically defines everything that someone acquires during the marriage as a marital asset. The main three non-marital components are those things that either spouse came into the marriage with, those premarital assets, those things that they may have inherited during the marriage, or things that may be excluded by way of a valid contract. So if they have a prenup, a postnup, or even a separation agreement, those things could be carved out. Sometimes it gets a little tricky because there can be partially marital and partially non-marital depending on the particular asset.
Yes, and we'll get into that because I find that very often the character changes a little bit and the way they've used those gifts or money and assets. But also, I did just say assets, but I think it's important for our clients to know debts as well, right? Like, I mean, if it's a premarital debt, let's say I think an easy one is a student loan that was before the marriage, that's just going to stay with that person as well, which is good to know.
I would say in Maryland, even if that student loan debt was acquired during the marriage, it's actually going to follow title.
See, and that's different from Florida.
So if I went to law school while I was married and I incurred, student loan debt, even if we got divorced, I would be the one that would be responsible for that student loan debt.
Yes, and I think that's the way it used to be here in Florida. Then it switched to during the marriage. But also, just for our listeners, that's really important to note because very often student loans get consolidated. There's all of these salespeople out there on the student loans, and they're wanting you to maybe join yours together with your spouse or pay it off with your HELOC. Be very wary of that if you're concerned about then being responsible for your spouses. Like, now, if you're the one with the debt and you're like, hey, let's make this marital, okay, go for it, I guess. Now, how do you advise your clients, like in these situations, and they're just trying to understand what is what's premarital, what's marital? How is this going to affect me?
Yeah, I really kind of talk through that with them, depending on what the asset is. So as we were saying before, some things may be a part marital and part non-marital. So the common example we see is a retirement account, right? So they were working at that company before they got married. They may have had $10,000 of that was a premarital asset, and now they have another $100,000 that they earned during the marriage. That extra $100 that they accumulated during the marriage is now a marital asset. So it's really kind of going through each of those assets and helping them determine, what is going to be considered marital and non-marital.
And I think that's so helpful because I would bet you have heard this from a client. Wait, no, that's my retirement.
Yes, all the time.
All the time. No. I'm the saver. He runs up the credit card. No, those are my savings. And those are harsh realities, I think, for people, coming maybe just for the consultation or just trying to explore the idea. That one takes a while for them to absorb that, I think.
Absolutely. Especially if you are the one that was the saver and the other person was not.
Indeed, it is. Now, how often do you deal with clients that have received an inheritance and dealing with that particular asset?
It comes up pretty regularly, right? The question then becomes, have they already commingled that inheritance? Most people just aren't thinking about it, and they don't know that they shouldn't take that inheritance and then put it into the joint bank account or the joint brokerage account, because as soon as they've done so, now that non-marital inheritance becomes a marital asset. And so if I catch them before they receive the inheritance, we can often, protect it. But sometimes they've already commingled it, and then it's a harsh conversation, about what they may be looking at if they are not able to reach an agreement with their spouse.
Yeah.
Typically on custody issues, property is not necessarily mandatory unless both parties agree.
Okay, well, here in Florida, it is required no matter what prior to going to trial. Some courts are more harsh than others as far as how much they will let you get in front of them prior to mediation, but regardless, it is required. So, that's where for our listeners, I just want to say in mediation, not always, but it's possible. Well, always it's possible to be creative and work through things, but there is an opportunity to maybe fashion something in a way that most likely won't happen in front of a judge.
100%.
And likewise, like with an inheritance, because, I bet you've heard this a lot too. I think everybody has, well, wait. We use my inheritance to remodel the kitchen, so I want that off the top if we have to sell this house. And that is, that's going to be a real tough sell. Like, you're not going to get it in front of a judge, and there may be ways, but really it's not going to happen.
I would agree. And fortunately, a lot of the couples that I work with are coming to mediation before they even get to the litigation side. So many of them are more open to being, more creative and more amicable about how they structure things.
How much of your practice is clients with attorneys coming to mediation or just on their own? Is it a mix?
It is a mix, but I would say the majority of them are actually do not have attorneys.
Okay.
Even though we recommend that they, consult with attorneys throughout the process, so many of them tell us they don't want attorneys because of how complicated they're worried that it might be.
And that's very true. It's, obviously depending on what's at stake, right? And how close or agreeable they are, I think that can, make a difference. But now let's talk about, we were talking about inheritance, premarital property, and gifts. Let's talk about gifts, because I know that one hits home, can be really difficult in some of the divorces that we deal with. That, let's talk about, is gift marital or not? And how do you advise your clients?
This one is so tricky. And I recently had a mediation where this came because one spouse would often give, a special handbag or jewelry as a holiday gift, or, a birthday gift, or, that sort of thing. And I think if it was a court situation, I think it really would depend on the judge as to how they saw that, right? Because marital funds were used to purchase that gift. So is it really marital or is it really a gift? I think that's where there's some murky lines, right? Now, a third party gift is a lot clearer. If a parent provides their child with a gift of a down payment for the house, I see that often. But then I also see the parents giving the couple a wedding gift of the down payment. So, it's really, is it to one individual, i.e. that person's child, or is it to them as a couple? So I think those are some of the distinguishing questions.
Now, that's an interesting thing. So if, let's say, parents of the wife gave the wife, $20,000 towards a down payment, would she be able to argue, do you think she could be successful in getting that portion out of the marital home?
I think it's definitely a possibility.
Okay.
And I often see it in mediation, yes.
Okay.
It gets a little trickier when they jointly title the house, because legally, at least here in Maryland, once they've done so, it's now a joint asset. But oftentimes we are able to trace it back out.
Okay. Now let's talk about engagement rings, because I want our listeners to hear this. How do they treat them in Maryland?
I think it's a premarital gift. It's a premarital asset.
But then that 10-year anniversary, you got an upgrade. Now what happens?
That's back to, is it a gift or was it a marital asset because the marital funds were used? Depends on which side, who you're representing, right? Yeah, I would think that more likely than not, the upgrade during the marriage is probably going to be a marital asset.
Yes, and I think that's important for our listeners to hear and understand. And we're not saying refuse that. Just, I think the more our clients are educated, it just helps absorbing the information, because I think information really helps you figure out, okay, now at least I have a clear understanding. Because, we've had cases where there was a lot of jewelry and, let's say, artwork. And most cases, the woman has more jewelry than the man. Not to say they don't have expensive watches. Sometimes they do. But we've done personal property appraisals. And I think that what our listeners don't understand is that they have, there's a value there. And it's going to get put on one side of the table versus the other. Different from, say, the luxury bags, which their resale isn't as much unless it's one of the Birkins, right? That's the one that is that still holds some value. It really is not.
Mm-hmm.
I mean, but if they start really whittling them all down, and it's on your side of the sheet, it can be substantial. And it's all these wonderful things that were gifts or bought during the marriage, but they're not going to help pay the bills.
Right. Yeah. The only thing you can really hope for in those scenarios is that maybe husband doesn't have a lot of jewelry, but maybe he has a lot of cars that he wants to keep.
Guns can be extremely valuable. I don't know much about them, but I know they're expensive. And I think they pretty much hold their value to some extent.
Yeah, I don't see it very often, but it's definitely one of those assets to be mindful of.
One thing that can be extremely helpful, and really it's smart overall, even though time consuming, is having a personal inventory of things that are of value, maybe just for your insurance purposes.
Right.
But those will be very, very handy in the event of a divorce. And it's so often those things just disappear, right? Like all of a sudden you're like, you had a Rolex. Oh, I lost that like months ago. And it's like, I don't know about that, right? But once it's gone, it's gone.
Right.
And I think that's in the area of guns because often, and let's play it both sides, right? Let's say, okay, handbags and guns, right? And the husbands don't pay as much attention, right, to the handbags or may not know how expensive they are. And maybe the wife, same with the guns. Like, okay, that's his thing. I don't really know. And at the end of the day, in a contentious divorce, it can really matter. And, or I think also, and you probably remember this from certainly when you were representing individual clients versus just the mediation, but that hindsight, that Monday morning quarterbacking going, what did I do? He walked away. Those were all these thousands of dollars of guns, or I don't think yard equipment is, but or car parts and cars. It's, if you think it is valuable, at least bring it up. At least have that discussion, right?
Absolutely, because you never know how much it may be worth. And it's not necessarily that you want the asset, but you want to be able to offset that value with something else that's more meaningful to you.
Exactly, right? But I know you've had mediations like this because you've been doing it too long not to in family law, where it's like, okay, fine, take my purses.
Right. Yes, we just had one where it was like, well, the fur coat versus the selling of the upgraded ring, that sort of thing.
Yeah. And I know in a lot of ways, like it might be overwhelming our listeners hearing this, but it does get like that now, because I think especially when they're gifts, and for women, because I'm speaking, on behalf of women and our clients, it feels really personal and more hurtful, even though the divorce overall, yes, should feel hurtful, but like those things I think do really sting. And I think your spouse knows it, and that's why they do it.
I agree.
Yeah. And so you got to kind of develop a little bit of a thick skin for some of this to really maneuver it well, I think.
Absolutely, especially in that contentious situation.
Exactly. And even, I think what I've seen over the years, particularly in a divorce, we can get really emotionally tied to things that maybe otherwise we wouldn't have so much, but all of a sudden it can become a real issue in the divorce that can almost prevent settlement. Have you had those experiences?
100%. And, one of the main ones is the house, right?
Oh, yes.
It's so many emotions are tied to the house, even though most women recognize financially it may not make sense to keep the house and buy out the other spouse, especially with the higher interest rates and all of those things. But we think of them as, well, this is where we brought our kids home to. This is where our kids want to come home to, while they're coming home from college. We want them to have a safe place to land because, even though they're 18, they're not fully grown adults yet. And so we want them to have that safe space. And I think it's really, really challenging for women to recognize it's okay to be, somewhere else and have a different house if it's not going to be financially advantageous for them to keep it.
And I think some of the emotions too are, well, I don't want him living there. If I can't live there, I don't want him living there. And I think that goes back on both sides a little. It can a little bit, right?
Yeah.
Because especially the longer you've been in a house and the more you've made it just fit for you, your family, it makes it a little bit harder to imagine him or her getting the benefit of your design, your, the way it is now personalized. So that's a big hurdle in a mediation that I am certain you have to deal with often.
Yes, the house is always one of the most complicated factors.
But let's now get back onto the inheritance. Let's talk how does somebody protect their inheritance so it won't be divided or considered for division in the divorce?
Yes. So first and foremost is to keep it separate from any other marital asset. So the way that I always, advise clients is you receive that check, that asset, and you're going to put it in a completely separate bank account or a completely separate brokerage account. You're not going to put any other money into that account so that you can, trace everything that any deposits you would really, I personally suggest not putting any additional funds into the account because it could be a marital asset. You don't want to get your bonus from your work and then put it into that account because that could commingle it. So you're just going to keep it separate. And then if you use any of those funds for like the vacation or the house upgrade or what have you, know that portion of it is probably now marital. So if you want to keep it completely separate, it should only be used for, something that you want to purchase and that you plan to keep non-marital. So an example would be, if you bought a car outright, right? Then that car is now going to also be non-marital since the source of the funds used would be a non-marital source.
Unless you put both names on it or give it to your husband. And I'm going to say women because I feel like men tend to be a little bit more savvy in the way they title things for whatever reason. And women feel like, oh my gosh, of course I should put it in both their names. And I'm not sure if it's the agents, who it is, but they encourage women to put both names on it, probably more so than they do men. And maybe women are more susceptible to that. Now, a prenup, that changes things. And so I do want to talk about that because I do think it's important. And then also the postnup, because if many of our listeners are already married, it's not completely, impossible. So if you'll touch on that for our listeners.
Yes. So a pre and a postnup really are the same thing. It's just a matter of when they were signed, whether prior to the marriage or after. And they can carve out what's going to be considered separate and what's going to be considered a marital asset. And this really in a before marriage situation is making sure you're having that conversation. And I think so many couples don't have that conversation as to how they want to handle their assets and their finances. And I think a prenup is a great time to have that conversation. It can just be a decision as to how they're going to address those things. Postnups, I will say we see most often because one of the spouses has started a business. I would say that's the most often time that we see it come up. The other thing I've seen is because one party has gotten into a lot of debt or has taken out a marital debt, such as a HELOC on the house and that sort of thing, and they want to carve out exactly how that's going to be handled later.
I think that is a great example because I usually think of a postnup as, women will ask us and it's like, okay, well, what's the incentive for him to sign? Right? So typically maybe there has been some breach of trust, such as, incurring a lot more debt or an affair. And as they're working to stay married, I think that is a place where it's used as a tool very often, saying, okay, well, this is where we are and I'm willing to work on it. But if it doesn't work out, like you've got to be willing to take this debt or let's iron out how things will come into. Now, do you see people ever coming to you wanting a postnup knowing an inheritance is coming?
I can't say that it's something that I've experienced.
And usually, and I think that would be possible. So if you're listening, you're like, yeah, my husband did bring that up. I mean, you do want to know why, right? Like, does he have some windfall coming and he's thinking, hey, I don't want to have to share this, and it could be marital. So I think you should always ask. And that is the question. It's like, why? And what's, in it for both parties? And I think it's important. It's a great discussion to have. And, with the rate of divorce and how expensive it can be, and we know how contentious, if you're able to talk about things when things are good and how it would be fair to distribute things, you're probably better off. And then you're not subject to necessarily what the law determines, because the law is not necessarily always fair in most people's opinion.
Yes, absolutely. Anytime a couple can resolve things on their own, it is going to be better in the long run. And sometimes it's even just narrowing a few of the issues. So that those are not things that are going to be fought about later.
Agreed. And now let's talk about this. Gifts for children. Mm-hmm. And when they're still minors, because I think there's, a lot, what would be the most basic one, like a car or something? Like how do you deal with that? How do you help your clients understand what we're going to do with that case?
So gifts for kids, I see that pretty regularly when we're talking about cars or 529 accounts. In my experience, the majority of the time, the parents both kind of recognize this is something we've already earmarked for the children, and they will just put language surrounding that. So it may be that, for instance, the car is in the husband's name, but the parties are going to agree that this is going to be used for, the child is going to use it, and upon them turning a certain age, it's going to be transferred to that particular child. So that would be what I have most often come into contact with.
And I think by the time, I think sometimes, clients feel like, oh, they're fighting, that's going to be on my side of the ledger. But usually by the time mediation or let's say mediation fails and you end up going to court, I would say for our listeners, most of the time, if your husband's been playing that hard line, they're going to back down, because then that looks really petty to the judge. And it really looks like you're just trying to put this $5,000 of value on your wife, but it's for your child. So I do think those work themselves out, at least with the automobiles. But I do want to talk about educational accounts. Here's a scenario. Say the grandparent establishes the account for the kids. And, when we look at them, we're looking at, well, whose name is on it? Because there's usually the adult name plus who it's earmarked for the child. And I'm wondering, if it gets to litigation, in these types of cases, say in Maryland, would the court then say separate, or do you think they'd let that in to the marital estate?
I think here it would be carved out. I mean, especially if it's in a grandparent's name, because the court has no control over an asset owned by someone else. And that grandparent doesn't necessarily have to give it to that particular child, right? Because they could move the money to another grandchild. They could decide they want to go back to school themselves. So I don't think if the account was in a third party name that it would be included in the marital estate here in Maryland.
Now, what if grandparents put mom's name and the child, with it, and for simplicity, money just came from the grandparents,
right?
But mom's name is on it, for the benefit of the child. You think they'd still carve it out at the end of the day?
I think so, because it's meant for the child. I don't think I've seen a scenario where a child college account was included in either of the parents' or the spouse's names.
I think when it comes down to it, sometimes it can be litigated a bit. We have the 529, and then in Florida, And this one's much easier because it's really Florida prepaid.
Right.
So they have bought that tuition and maybe room and board like locked in at that rate when the child was much younger. And I think that's where we can get creative in mediation as far as, hey, this is for the benefit of the child, and agreeing that even though the parent's name is on it, they're not going to withdraw anything or take it for another use.
I commonly see clients basically say it's going to be used for the children for educational purposes only. And this was more so before the recent Roth IRA conversion option, where if there happen to be any funds left over, which doesn't happen often. It's very rare that they have overfunded the college account, but there's often language that said, if there happened to be any money left over, that they would split it equally. It's not that I have actually run into that scenario very often, but at least that puts some language in there as to what's going to happen to it if there happened to be an overfunding.
Which would, I think seem fair. If they have any left over and, they can use it without penalty, then they should, or convert it to a Roth IRA. Now, let's talk about, since we're talking about inheritance, and in Maryland, are you able to disinherit your spouse in Maryland with your will?
No, you are not. There's a statutory spousal election. It's a percentage, and off the top of my head, I can't remember the exact percentage. It depends on if they have minor children or if they have adult children, but you cannot completely disinherit a spouse in Maryland.
And same in Florida. And for our listeners, that means both states, we have laws that if you don't have a will, this is how your estate will be divided. And that will depend on, whether you're married or not, or your children. But if your will gives maybe your spouse less than they would be entitled to, basically you're probably setting up a lawsuit to happen afterwards, because that is essentially giving them less than they're allowed by law. For our listeners to know, because also that creates a lot more expense out of the estate and money leaving for lawyers rather than the people you intended it for.
Yes. And the other thing I would say, just to go back to the prenup, I see this often when we're talking about second marriages, right? Or subsequent marriages, where you may have children from your first relationship and you want to give the majority of your assets to your children instead of the second spouse. That's another good reason to have that pre or post-nup, because in that scenario, that spouse can waive their right to receive that inheritance so that you can pass along those assets to your children.
Yes, and I think that is so important for many reasons, because no one knows really what you truly wanted once you're gone. And so therefore, it's so important for spouses, particularly in a second marriage, when you've got children, you're both coming in with assets, but you may accumulate things together and it just muddies it up. You may want certain things for your kids, or maybe you don't. But either way, a prenup is such a great way to address all of that and make it simpler for anyone else after you've passed. Now, I would love to know if you can divulge like any interesting cases that you've had, maybe that had inheritance issues or gifts, throughout your years of practice, without divulging anything confidential.
I think the most interesting one has been, the scenario of the various personal property and how we were going to deal with that. Because in that particular situation, a lot of the gifts were, during the marriage, they were jewelry or expensive handbags that were sometimes an apology present for things that took place in the marriage. And how to deal with those became quite complicated, because there's yes, it's really marital by the understanding of it was purchased with marital assets, but is this, there was the emotional side of things that we really had to contend with. In the end, they were able to work it out, and basically they each kept their own personal property. We didn't do an evaluation of any of those things. I think there was just one one piece of personal property that they both agreed was going to be sold, and then they divided those proceeds. But that was one of the more complicated mediations to deal with when we were dealing with those types of assets.
I have another question, though, about if you've seen cases or if you think it's common for people maybe to try to defer an inheritance or hide money ahead of a divorce.
Hide money, yes, I've seen people try to do that. I don't think it's very successful in this environment. It's really complicated to hide money. The only people that really are truly successful in hiding money are those folks who have cash businesses. Even then, a lot of times they will deposit a portion of that cash. But I think that's the most difficult piece to trace, is when we have cash businesses, whether it's I had someone who owned a bar, or, people who receive lots of cash in tips and that sort of thing. Pretty much anything else is going to be traceable. And I know people are always concerned that someone's going to be hiding money, but usually it's in the bank records. It's almost always in the bank records.
And you may have to go far back, but it's very much a suspicion often.
Yeah.
And it has to be looked through. Cash is cash. It's difficult. And if it's not there, it's not there. And so if your spouse, and I've certainly had these cases, like we held a lot of cash in our safe, take pictures, do something, get it accounted for, because that's when it's gone, it's gone. Or like gold, things of that, because now it's in your possession, there's really no record of it. And that can end up being quite valuable. And I understand, if you don't pay attention, then it's gone. And usually there's not much the attorneys can do for you in that case.
Yeah.
Well, Cary, I can't believe we are at the end of our show. This was a great conversation. I really appreciate it. And before we go, can you impart on our listeners what you've learned about women and their resilience throughout your career and experience?
I think women are just incredibly resilient. I think, honestly, by the time they have made the decision to get a divorce, it's been building up for many years. We all know that women, initiate divorces much more often than men, but it's because they've exhausted all of the options and they've tried for so long and it just hasn't gotten better. And then they finally decide that they can't continue. But so many of the women that I hear from afterwards say how much better their lives have been because they have finally taken that leap to really put themselves first.
And that has been my experience as well. And lastly, Cary, where can our listeners find you for more information and resources?
Yes, so the best place is to find us on our website, which is jacobsonfamilylaw.com. And we also are all over social. We have a YouTube channel where we try to put out educational information, tips along these lines, TikTok, LinkedIn, Facebook, pretty much any of the social media channels.
Well, thank you so much. And we've reached the end of our show today. And thank you to Cary Jacobson for joining us to discuss inheritance, gifts, and what is and what isn't considered marital assets.
Thank you so much for having me.
Absolutely. And for our listeners, if you or someone you know is going through a divorce or is thinking about a divorce in the Northeast Florida area, please reach out to us at FloridaWomenslawGroup.com. And you'll find our practice areas and the link to our website in the show notes, as well as Cary's links. Thank you for listening.
Listeners, if you or someone you know in the Northeast Florida area is going through or even thinking about divorce, you're not alone. Taking that first step can feel overwhelming, but it doesn't have to be. Our newsletter is filled with actionable advice tailored to guide you through this process. By signing up, you'll gain the tools to face the unknown with courage and see if we're the right fit to support you during this life-changing time. Don't wait. Click the link in the show notes, fill out the form, and take the first step toward building a brighter future today.